Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzeli, and Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by DocketWise, an all-in-one immigration forms and case management solution trusted by thousands of immigration lawyers across the U.S. I really like DocketWise. It makes immigration applications easy by allowing the clients to provide information through simple online questionnaires that are shareable by text or email and available in multiple languages. Not only that, DocketWise provides a comprehensive group of case management features, including invoicing and calendaring, secure messaging, task management, and a lot more. You can learn all about DocketWise and receive a 10% discount on your subscription by heading to docketwise.com/immigration-review so they know we sent you. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. What a week this first full week of November 2024 has been. If you're like me, you didn't vote for Donald Trump to return to the presidency. You're devastated that his brand of politics was embraced by so many Americans, and quite frankly, you're nervous about his stated policies and what it all means for democracy in the country. On top of all that this week, a federal judge in the Eastern District of Texas, a venue specifically chosen for forum shopping purposes, held that President Biden's parole-in-place policy for certain spouses of U.S. citizens not only is improper, but actually violates INA Section 212d5, which not only dashes the hopes of thousands of mixed-status families with no criminal records, but puts things even like military parole-in-place in jeopardy. It has been a week, and there will undoubtedly be more of these to come over the next 4 years. I'm not going to sugarcoat it. Those of you who were around for it last time know that the non-citizens bar is in for a fight. It's going to be a lot. But that's why most of us became immigration attorneys, right? To represent the most vulnerable. It's often more than a paycheck, for better or for worse. So really then, who better to fight than us? We know immigration law better than they do, and we certainly care more about our clients. Each of us will represent our clients and defend non-citizen issues in our own way, and I promise you, whatever you choose to do over the next 4 years will be enough. Take time for yourself too, for your family and for your personal life. Embrace it all over the next 2 months, and carve out time for yourself over the next 4 years. Because we're going to war, and well, warriors need to be well rested and emotionally stable. Warriors also need to know the law. I've just had a child, but I don't intend to stop my older child, the podcast. And the circuits will certainly continue to issue non-citizen-friendly decisions, and other decisions that we can employ as some of our best weapons in the fights to come. Heck, there were 2 issued this week. I myself am recording this introduction from a hotel room in Monterey Bay, California, where the AILA California chapters held their annual conference this weekend. And well, it all reinforced quite clearly to me that the immigration bar represents the best of us, and that we will prevail for ourselves and for our clients. Don't forget to celebrate the wins and celebrate one another over these next 4 years. And it's time to get to work, for our clients and for the country. You're probably hearing a lot of buzz about how law firms are starting to use artificial intelligence. And well, I recently had the opportunity to talk to the folks at Serenade about their case management system, e-immigration. They've been making software for immigration attorneys longer than anyone else. And they're doing some pretty cool stuff with AI. They have a suite of tools that they're calling AI Workmates. That sounds like it's got huge time-saving potential. One of their tools even lets you upload a PDF and instantly creates a client profile. There's another tool that can read content on the website and instantly summarize it, which is pretty helpful when referencing historical case rulings or, dare I say, country condition evidence. They've got some other tools too scheduled for release later this year. So if you're trying to wrap your head around how to use AI in your practice, I encourage you to have a chat with the folks at Serenade. Also, check out their blog at serenade.com/blog for their recent articles on AI in legal practices. Or, of course, click on the link in the show notes. Are you struggling to find and hire new talent that you can trust? Does the idea of onboarding, training, and managing virtual staff overwhelm you? Staffy's got your back. Staffy provides top-quality virtual staffing for immigration law firms, complete with HR support to free up your time from the hassles of onboarding, managing, and continuously training your virtual staff. With an entire team of professionals, including psychologists and mindset, task, and performance coaches, Staffy ensures your virtual staff has all the tools needed to help your law firm grow and scale. Visit staffy.cc, that's stafi.cc, and schedule a consultation to claim $500 off your first month of service. Or, of course, click on the link in the show notes. Starting off with Reid v. Garland, published by the Second Circuit on November 5th, 2024. This case is about former INA Section 212C relief and mental competency, and it's a long one. Fittingly, then, the government has been trying to remove Mr. Reid for 30 years, so long that he's actually in deportation proceedings. So technically the government is trying to deport him. It appears that Mr. Reid is a lawful permanent resident from Jamaica and has some serious convictions, and in those 1995 initiated proceedings, he sought a former INA Section 212C waiver. There have been at least 2 remands in this case. It would appear that no later than the mid-2010s, Mr. Reid started suffering from some serious mental health issues. Finally, in 2019, an immigration judge held a hearing pursuant to the BIA's seminal matter of MAM decision to determine whether Mr. Reid was competent to proceed with his removal proceedings, as is, or rather whether certain safeguards needed to be implemented to protect Mr. Reid's constitutional due process rights. By this point, he had attorneys, but he was not cooperating with them. And so they moved to terminate proceedings, arguing that no matter of MAM or matter of MAM safeguards would work in a case where, as here, the non-citizen's mental health condition is leading the non-citizen to refuse to cooperate with counsel, believing, as was the case here, that the attorneys are working with DHS prosecutors and the IJ to remove him and otherwise conspire against him. The medical evidence showed in this case that Mr. Reid suffers from schizophrenia, serious hallucinations, and delusional thinking, and that he hears voices all the time. He also refuses to take his medication. The IJ ultimately did not terminate proceedings and reserved a formal decision about Mr. Reid's competency, but believed that regardless, the safeguards that had been implemented were adequate as is, and that the IJ would implement other safeguards if needed. Ultimately, the IJ stated that she believed counsel could, quote, work around, end quote, Mr. Reid's mental illness, but the IJ, quote, did not articulate how and why, end quote, that could work. At the merits hearing, the IJ's safeguards included not requiring Mr. Reid to testify, relying on the objective evidence in the record, considering uncross-examined witness affidavits, letting Mr. Reid be unshackled during the hearing, kind of scary and strange, and not wearing a robe to accommodate Mr. Reid's distrust of the judicial system. The IJ ultimately denied Section 212C relief and Convention Against Torture protection, while acknowledging that Mr. Reid, quote, could not assist his representative in his defense, end quote. The IJ explained many reasons for denying on the merits, but they're not relevant here, to be honest. The BIA affirmed, believing the safeguards instituted were sufficient to protect Mr. Reid's due process rights. The Second Circuit remanded. Removal proceedings, or I guess here deportation proceedings, are weird. Have I mentioned that on the podcast? Quote, unlike in criminal proceedings, a lack of competency in civil immigration proceedings does not mean that the hearing cannot go forward. Rather, procedural fairness is required, end quote. That's from the BIA in matter of Mam, which again told IJs to ensure that adequate safeguards are implemented in removal proceedings where there exist mental incompetency issues. But the BIA didn't precisely detail what safeguards should be or what would be required. Lots of examples were provided in matter of Mam, though. And that makes sense, as mental incompetency is probably very different from person to person. Termination of proceedings was even included as a possible safeguard, at least in a later precedent that is matter of MJK. Reviewing and kind of jumping off from matter of Mam, the Second Circuit implemented a whole bunch of requirements on IJs sitting in that circuit. First off, what is competency? Well, from matter of Mam, quote, "A respondent is competent to participate in immigration proceedings if he or she 1. Has a rational and factual understanding of the nature and object of the proceedings, 2. Can consult with the attorney or representative if there is one, and 3. Has a reasonable opportunity to examine and present evidence and cross-examine witnesses." End quote. None of that appeared to be the case here. Mr. Reid did appear incompetent. Big problem to the Second Circuit, though, was that the IJ never expressly made a competency determination, the nature of the incompetency or the factual reason for the finding. That's important because an IJ, quote, "must tailor safeguards to the delineated character, scope, and severity of the non-citizen's incompetency," end quote. So how can you know what safeguards suffice if you haven't first outlined the severity of the incompetency? Reasoned the Second Circuit. The court believed that matter of Mam requires this, too. To be clear, there is a presumption of competency in removal proceedings, but the Second Circuit and really even the IJ seemed to believe it easily rebutted by Mr. Reid's actions and the attendant medical reports. Important stuff for the court because, quote, "to order the removal of someone unable to participate meaningfully in his or her removal proceedings without adequate safeguards would make the whole process a charade," end quote, quoting the Fourth Circuit. The Second Circuit explained in a footnote that administrative closure and termination of proceedings are definitely options, but maybe not for someone like Mr. Reid who is detained the whole time and who has serious criminal convictions. Admin closure, after all, in that scenario might lead to indefinite and unconstitutional immigration detention. What to do? The Second Circuit was a bit unsure here, because again it believes that the IJ failed to adequately make a competency finding or explain the scope of the competency. And so how could the court, review whether the safeguards implemented sufficed, or whether additional safeguards were needed? IJs can't just rely on the fact that incompetent individuals have counsel as an adequate safeguard, as appears to have largely been what occurred here to the Second Circuit, and particularly where everyone recognized that Mr. Reid couldn't assist his attorneys. It didn't matter that apparently Mr. Reid and or his attorneys in removal proceedings didn't ask for additional safeguards. An IJ must explain why the safeguards implemented and rejected are, quote, "tailored to the non-citizen's limitations," end quote. It is not the incompetent non-citizen or his attorney's burden, explained the Second Circuit in a footnote. So again, what else to do, though? Well, while the Second Circuit is sending it back due to the insufficient findings and analysis on competency, it seems like the court believes continuances or even administrative closure for treatment could have helped, given that Mr. Reid's psychologist and social worker testified that it might help. Particularly important here because Mr. Reid's participation in his proceedings and knowledge of his factual history was actually pretty vital as to whether he was statutorily qualified for former Section 212C relief. Maybe other safeguards required too, explained the court. So, there was a violation. Really a regulatory violation regarding a failure to conduct a proper competency analysis and institute appropriate safeguards. But OIL argued, as it always will, that still nothing should change despite the violation because Mr. Reid can't show prejudice as a result. Incorrect, in the Second Circuit at least, for this type of regulatory violation, and in my opinion, though, many others. Quote, "Whereas here, a respondent claims that an agency has failed to adhere to its own regulations regarding a fundamental right derived from the Constitution or a federal statute in a deportation hearing, he is not required to make a showing of prejudice before he is entitled to relief," end quote. Know your regs and use that quote in your termination briefs because that's a big one. In any event, the Second Circuit believed that Mr. Reid was prejudiced, as again, there were many facts that only he knows that might change the IJ's basis for denying former Section 212C relief. Remanded. And heck, if Mr. Reid can't be found competent on remand, or the safeguards are inadequate, termination of proceedings might be required. Explain the Second Circuit. Quote, there are no barriers to administrative closure or termination of proceedings, end quote. At least so long as the new Trump Attorney General doesn't come into power in January. The Second Circuit might as well have said that because it cited to Attorney General Garland's decisions in cases like matter of Cruz Valdez and matter of Coronado Acevedo. Election results are literally coming in as I read and record this decision. So my goodness. Congratulations Andrew D. Bergman from Arnold and Porter, and Molly Lauderbeck and Sophie Dalsimer from the Brooklyn Defender Services in Brooklyn, New York. Not to mention a whole bunch of amicus, including that roundtable of former immigration judges and BIA members who just seem to be everywhere these days. And that is Reid v. Garland. Meaning that we conclude with Morgan v. Garland, published by the First Circuit on November 5th, 2024. This case is about serious non-political crimes and cat protection. Mr. Morgan is from Jamaica and entered the United States without authorization in 2022. ICE somehow caught up with him in Hartford, Connecticut, and initiated removal proceedings, where Mr. Morgan applied for asylum and related relief and protection. In support of those applications, Mr. Morgan asserted that he was wanted for a gang murder in Jamaica, but that really, it's a, quote, trap from the government of Jamaica and the police against me, end quote. He asserted in his asylum affidavit and testimony that the police and gangs are working together against him. Mr. Morgan conceded that a murder occurred, but he asserted all along that he didn't do it. ICE asserted that there's actually a warrant for his arrest in Jamaica. The story Mr. Morgan told is actually a long and pretty complicated one about inter-gang rivalries and his family. Mr. Morgan and his brother, who is gay, were harmed physically and terrorized by a gang in Jamaica. Police promised to help but never did. More attacks followed. The gang even poisoned the family's livestock. Then police themselves got involved in early 2021 in a terrifying and violent way. More too, and quote, several witnesses, including Mr. Morgan's brother, sister, fiancé, sister-in-law, and friend, also testified on his behalf, end quote. The IJ denied everything. The IJ held that DHS had established serious reasons for believing that Mr. Morgan had committed a serious non-political crime abroad, murder, and that Mr. Morgan hadn't met his burden to rebut. That's a bar to asylum and withholding of removal under both the INA and the Convention Against Torture. To meet its initial burden on that, I submitted documents about the murder, 3 arrest warrants from Jamaica, and a Jamaican police report which, quote, names Mr. Morgan as one of 4 suspects and notes that he is a fugitive, although it does not precisely describe the basis of this identification, end quote. Then the IJ denied cat deferral on the merits. The BIA affirmed. The First Circuit affirmed in part and remanded in part. It affirmed the serious non-political crime stuff. Explained the First Circuit, per BIA precedent and every other circuit to have addressed the issue. DHS's initial burden to establish serious reasons for believing that an asylum applicant committed a serious non-political crime abroad is a probable cause standard. That's the 2012 matter of EA decision out of the BIA. And pursuant to criminal law precedent out of the First Circuit at least, that equates to a, quote, fair probability, end quote, standard. And as a criminal law concept, all circuits will have different case law on what probable cause means. In the First Circuit, quote, a finding of probable cause can be supported by less evidence than is required to support a conviction, and not all plausible lawful explanations of the situation must be negated, end quote. That's what DHS's initial burden is. DHS's evidence met that here, explained the court, or at least the record didn't mandate reversal. Quote, although these documents do not demonstrate the precise means by which Jamaican law enforcement came to identify Mr. Morgan as a suspect, the IJ reasonably inferred from the narrative that the eyewitness to the shooting attack identified Mr. Morgan as one of the 4 perpetrators, end quote. Yes, the reports and warrants are not perfect and could use a lot more detail, and some might even have significant flaws, but, quote, probable cause determinations are to be informed by the totality of circumstances and not by the consideration of different pieces of evidence in isolation, end quote. And Mr. Morgan was deemed a fugitive from Jamaica at the time that he left. The First Circuit even sees a potential motive for the killing, revenge for the assaults on Mr. Morgan and his family. That was not merely like the Interpol Red Notice at issue and rejected, I think, in Gonzalez-Castillo v. Garland out of the Ninth Circuit on episode 123. Explained the First Circuit without the episode citation, of course, and in a footnote. But hey, check out that discussion on episode 123, no? To the extent that the IJ may or may not have adequately considered Mr. Morgan's rebuttal evidence, the First Circuit doesn't say and didn't consider the matter, as it was not argued below before the BIA, and so the court deemed it unexhausted. But you still have Convention Against Torture deferral. Nothing can bar that. It must be decided on the merits, which the IJ and the BIA did, of course. But they did not do so adequately, explained the First Circuit. 4 arguments presented, but only 1 adopted, so let's do that because these First Circuit decisions have a way of getting really long. To the court, the BIA failed to adequately address Mr. Morgan's claim that he suffered past persecution by the gang with the acquiescence of Jamaican law enforcement. CAT by private actors, like gangs, of course, requires government acquiescence or consent, and the police are generally considered government actors. Unlike with asylum and withholding of removal, past torture doesn't create a presumption of future torture, but it's important and must be considered. It is not the case, explained the First Circuit, as the IJ apparently assumed that, quote, acquiescence requires active cooperation between the police and the direct perpetrators of putative torture, end quote, and can't be simply met by inaction. Rather, in the First Circuit, quote, acquiescence occurs when 1. Officials are aware of torture, and 2. Thereafter breach their legal duty to prevent such activity, end quote. I believe that's called willful blindness. As such, under this definition, quote, an act is cognizable as torture, even where the official directly responsible for it does not actively cooperate with the law enforcement personnel charged with preventing torture, end quote. Seems like a pretty important standard, no? To the court, the argument wasn't just about Jamaican police being under-resourced or prioritizing other crimes. The assertion here was that the police always outright refused to assist in protecting people from this gang or this kind of gang violence, and that they even promised to investigate Mr. Morgan's case and then didn't. So the matter was remanded for further fact-finding regarding exactly what the Jamaican police's inaction of the past meant for Mr. Morgan's ability to show that he was tortured in the past and would be tortured in the future. To be honest with you, I was a bit confused at this point in the decision, which I promise is towards the end of the decision, because there hadn't been much mention of credibility, but it seemed that an adverse credibility finding had been made. And indeed, it was. But the First Circuit didn't like that either. Quote, all of the IJ's credibility findings in the CAT deferral context were tailored to her erroneous view of acquiescence, end quote. That is, the IJ seems to have believed that because Mr. Morgan's witnesses and Mr. Morgan himself didn't know enough about the police's affirmative cooperation with the gang, they weren't credible enough on this issue. But the First Circuit rejects that base premise. Or at least it deems it insufficient. Other arguments that Mr. Morgan made were rejected, but hey, it's a remand. Meaning, congratulations Sang-Yup Kim and Giles Bessonette from the ACLU New Hampshire. Reading and analyzing this decision after the election, I can tell you right now, ACLU will have a very important role to play in the next 4 years. And that is Morgan v. Garland. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzeli, and Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review, or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook @Immigration Review, or send us a tweet at IMReview. That's IMM Review. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.